So there's two laws here, if you will. AB 1482, which is statewide rent control, went into effect in January. Then here most recently, AB 3088, which essentially deals with non-payment of rent, the COVID issues, and evictions and so forth.
Correct.
Under AB 1482, it allows for a landlord to issue 60-day notices to vacate if they plan to do substantial improvements. And I've done a video on this, so we won't go into detail. We'll link to that video as well. This question is with respect to AB 1482. Can a landlord evict a tenant currently in order to do these substantial improvements?
The short answer is no. Under AB 3088, all residential rental units, including single-family homes and condos, are subject to the just cause eviction limitations of SB 1482, just like you just said. And while SB 1482 normally allows no-fault evictions for substantial remodels and what they call demolition, AB 3088 specifically carves those out of the just cause eviction. So in other words, even if you would normally be allowed to do that, currently you're not allowed to do that until after February 1st of 2021. In other words, you can't terminate the tenancy for a substantial remodel or demolition until next February. And it's reasonable to expect that that date could be pushed back if these COVID numbers continue to increase.
But nothing prevents a landlord, if their local city or county doesn't prevent it, nothing would prevent a landlord from a cash for keys program, correct? In other words, if the tenant agrees to some monetary payment to leave and go on their way, and even though you're paying the tenant to leave because you are going to do substantial improvement, the fact that essentially the tenant went on their own accord, nothing would prevent the landlord from doing so, correct?
That's absolutely correct. There's some subtleties to it that I want to draw out on purpose. Under SB 1482, when you terminate that tenancy, you've got to have the reason stated in the notice. So I would be cautious if you're going. You can certainly enter into these agreements, and I encourage landlords to enter into these agreements. You will want to look at your local jurisdiction and see if there's any requirement for what we call a voluntary vacate agreement. I'll give you an example. In Los Angeles, if you enter into a voluntary vacate agreement with a tenant, this is under RSO, but if you enter into a voluntary vacate agreement, there are certain requirements. You have to have the tenant sign a document. That document has to be included with the voluntary vacate agreement. Both have to be recorded with the city. There's specific language that has to be included in the agreement right above the signature line in 12-point font. So the answer to your question is no, there's nothing that prevents a landlord from entering into a voluntary vacate agreement with a tenant as long as the moratorium doesn't prohibit it. And I don't, off the top of my head, I can't think of any moratoriums that prohibited that. Just make sure you're doing it correctly. Make sure it's got the right protections in it, and make sure it's structured in a way where if the tenant doesn't comply and doesn't vacate, you've got some sort of remedy in there to protect you. I've seen clients give the tenants a significant sum of money, and then the tenant didn't vacate, and now they're faced with trying to get the tenant to vacate or trying to get their money back, and both are uphill battles. So it needs to be done correctly.
Yeah, we've done this, my wife and I and our partners in our own buildings, but we never trade money until the keys are in our hands just because of that issue. So,
a little add on to that. I've had situations, it's very common for the tenant to come back and say, well, I need the money to vacate. And my response to that is, look, we might be willing to amend the agreement, but here's what I need from you. I need a signed lease from your new landlord. You present me evidence that you actually have a place to go, and maybe I'll write the check to your landlord. Or provide me with a lease and your new landlord's contact information. I'll reach out to them as long as they agree that they really intend to enter into a lease with you, and I'll just write them the check for the first month deposit, whatever they need. And then if you don't move, I'm going to get that money back from that landlord or something along those lines.
That's very clever. I hadn't thought about that. Yeah. Now, this next question has to do with unlawful pets, but I think this goes back to your example of when tenants move somebody in a unit that's not on the lease. So I think the general question is, right now, as of today, we're in the midst of AB 3088. If a tenant breaks some rule of the lease, whether it's they brought a barbecue inside the unit and then in your lease says no barbecues, they have pets and your agreement clearly says no pets. They bring people into the unit that are not supposed to live in the unit. For all these type of reasons, from what I understand, you can begin the process of an eviction.
That's correct. Under AB 3088, the answer is yes. You can start the eviction, and there's no special notice requirement for that. That's just a 3-day cure covenant or quit. But you already touched on it. Again, it depends on where your property is located. Read your local moratorium. Assuming your local moratorium doesn't prohibit that, then absolutely you can do that. But again, because of the retaliation code that's been beefed up, I would really document it well, what the violation is, especially with pictures if you can, like the barbecues, the animals. I would even go further with animals. I would document, especially where the animals may be defecating around the property or something like that. I would certainly take pictures of, I would follow them around, take pictures of it so that I can document it. So when I do bring the eviction and they claim retaliation because they didn't pay, half their rent way back in March, I've got evidence to rebut that and say, no, it's got nothing to do with that 50%, that $500. I'll go after them next March in small claims for $500. It's because they brought a dog in and they're violating the lease. And I asked them in writing in advance to get rid of the dog and they refused. I served them a notice. They refused. So this has nothing to do with retaliation.
And this is where I would highly suggest landlords, aside of the rental agreements that are out there, even if you're using some of the association agreements, I think you need a separate addendum that speaks to a lot of these issues. We have a separate addendum that legal counsel has created for us. You just want to wrap these tenants in a straitjacket, if you will, so that it's very clear the boundaries. So there is no questions, down the road. And I think that's where people get into trouble is having sold all the apartment buildings that I've had, I've seen a lot of different rental agreements, different versions. Some of it is just very general where there's a lot of gray area. Okay, drug dealing. What do you do with a tenant suspected of dealing drugs on your property?
Well, the key word there is suspected. You're not going to be able to evict somebody for suspected drug dealing. But if you really do suspect drug dealing, the first thing I would suggest is you contact your police. In LA, they have what's called a senior lead officer or a SLO. Find out who your SLO is, contact them, have them meet you at the property. You can sign a piece of paper and put it on file with the police department that allows them to come onto your property and arrest people, investigate. So I would put that in play right away. I would have the police department, if you ask your senior lead officer, in general, they will produce for you a report of all the calls that have been made to your property. And you'll see which units they've come out to. I would start building a case against the suspected drug dealer. Now, that's for a suspected drug dealer. And I really wouldn't say much to that tenant until I had more than a suspicion that they're drug dealing. Even if I'm getting complaints from other tenants, if those tenants can't provide me with verifiable evidence that it's really drug dealing, the last thing I want to do is bring it to the attention of the suspected drug dealer, upset that individual, and then maybe that individual is now retaliating against the other people who turned them in, creating a lot of problems on the property. So I would build my case against that. Now, there's other situations where we're not talking about suspected drug dealers. If you have somebody who's arrested on the property for drug dealing, or you have the police, a situation in which the police raided your property and kicked in a door, that's a whole different story. Now you've got a nuisance situation and you can do a 3-day quit based on that situation right there. But that goes further than suspected drug dealing.
Now, I had a landlord share this idea with me that when it is only suspicion, you don't have any evidence, you haven't seen it for yourself, it's being rumored amongst the tenants, issuing a notice to all the tenants that you've agreed to work in coordination with the local narcotics unit, and you've granted them permission to come on the property day or night to run tactical drills, right? So you're just putting the front that, hey, there might be narco dogs on the property just to get these people worried. And maybe it just, that bluff will have it end there. What are your thoughts on that?
As an attorney, my concern would be, things that you put in writing can come back and bite you unexpectedly. And so if you're putting that in writing, and let's say down the line, a tenant chooses to move because they feel like they're being singled out and harassed, and they bring a civil lawsuit against you for harassment, and they produce that letter as evidence, and then they say, and then it comes out that it was all a bluff. There was no coordination between you and the police department. It tends to make you look very bad in front of that judge or jury. So I would be cautious what you put in writing. But if you were to legitimately contact the police, like I said, and you can sign that document allowing them on the property to do that stuff, then that's legitimate. You could put that into writing and say, look, I've signed a document allowing the police on my property. You could even say, look, I have reason to believe there is drug activity going on this property. And out of a concern for my tenants, I care about you guys, I want to protect you guys. I've signed a document with LAPD, for example, allowing them on this property day and night to investigate, to run narcotics investigations, and to make arrests as necessary. That's all legitimate now. So my point is, if you're going to do that, I would not necessarily advocate bluffing it. You can legitimately do that and put out the same letter and protect yourself from that bluff coming back later to haunt you.